The purpose of this video is to just introduce to you what we mean when we talk about statutory interpretation. What is statutory interpretation? In general terms, statutory interpretation is the process by which a court ascertains what a statute means. Courts have to do this in order to ascertain the law that has been established by the statute in question. They have to do that before they can determine the law that applies to a particular case brought before them for decision. But there is a really important distinction to draw here between the process of interpretation and the process of application. Statutory interpretation means reading the statute and figuring out the law that it establishes, what we might call the legal effect of the statute in general. Only after doing that in a clear and considered way can we consider how a statute applies to a particular case or the legal consequences of that statute for a particular fact or event. Let me give you an example. You might have a statute concerned with social security. That statute will set out detailed criteria that establishes the categories of people who are entitled to particular forms of social security. The process of statutory interpretation involves reading that statute and ascertaining, in general terms, the nature of the categories of people who are entitled to that benefit. Only once we've done that could we then decide whether a particular person with particular characteristics is legally entitled to the benefit prescribed. So, we should always start with the statute and then move to the facts or events in question. We have to read, interpret, and apply in that order. In some cases, the meaning of a statute will be clear, but not always. Often, one statute or statutory provision will be open to more than one plausible interpretation. The first reason for that is that the English language is complex, and many words and phrases carry slightly different meanings in slightly different contexts. Let me give you an example. The word bank might refer to a financial institution or the side of a river. The word board might refer to a piece of wood or the committee that manages an organisation, or the meals provided at a house of lodging. The meaning of the word bank or board is unclear. We have to look to other evidence in order to ascertain what it means in a particular context. Another complexity of the English language that can make the meaning of statutes unclear is that certain words and phrases sometimes carry different meanings depending on whether they are being used in an ordinary or technical sense. In other words, the same word can mean something different to ordinary people like you and I when we use it in ordinary conversation, as opposed to when it is used in a certain technical context. Think of words like tomato and pumpkin. Now you might know that strictly speaking, tomatoes and pumpkins are fruits. But if you and I were having a conversation, we'd probably tend to refer to those things as vegetables. So, what should a court do if it finds the word fruit in a statute? Should it give it its ordinary natural meaning, or should it give it its technical, scientific meaning? This is not a made-up example. It is something that courts have had to deal with in the past. Finally, some words in the English language are just inherently imprecise. Take, for example, the word offensive. We might be able to look up this term in a dictionary and explain in general terms what we mean by offensive. But where is the dividing line between offensive and non-offensive? We can't give a really detailed description of what counts as offensive and what doesn't. What should a court do then when it finds the word offensive in a statute? This raises real questions about how it applies to different forms of conduct or communication. We're going to look at an example of this in the case of the World Youth Day legislation that we look at later in this course. The other reasons why statutes are often open to multiple interpretations is that statutes are not interpreted in exactly the same way as other texts or forms of communication. A statute is a written text. It is, in a way, a communication, but it's a very different form of communication from, for example, a letter you might write to a friend or a conversation you might have with a colleague. Enacting a statute is an expression of constitutional power. Parliament's power to make statute is derived and constrained by law, and the enactment of statutes has significant legal consequences, the most basic of which is that when Parliament enacts a statute, you and I and all the other branches of government are bound by it. Because statutes are an expression of constitutional power, there are a range of constitutional assumptions that inform how we expect statutes to operate. These translate into principles or presumptions of statutory interpretation, and their application may mean that the legal meaning of a statute, as ascertained by a court, is rather different from its ordinary natural meaning. Let me give you an example that we're going to explain in much more detail later in this course. At first glance, it might seem quite clear that a statute restricts the freedom of speech. But for reasons that we will explain, courts start from the presumption that Parliament is not intending to restrict freedom of speech, and so will strive to interpret statutes in a way that leaves that freedom unencumbered. So, for all these reasons, the meaning of a statute is often not clear. Or to put it differently, statutes are often open to more than one interpretation. That is why statutory interpretation is needed. The High Court has said that when it encounters statutes, as other courts do, it'll often face a constructional choice about which of the possible interpretations ought to be employed. The former Chief Justice of the High Court, Robert French, explained in a quote that I'll read for you, that this constructional choice reflects the plasticity and shades of meaning and nuance that are the natural attributes of language, and the legal indeterminacy that is avoided only with difficulty in statutory drafting. In simple words, that means what we said, that statutes are often open to more than one interpretation due to complexities of language, and due to the fact that statutes can be rarely drafted with absolute precision. So, the court's role is to decide the legal meaning of the statute or the interpretation of the statute that ought to be preferred in light of the established principles of statutory interpretation. But the fact that the courts have what we call a constructional choice does not mean that the statute can mean whatever the court wants it to. Here, another quote from the former Chief Justice Robert French is useful. As French explained in a quote I'll read to you, "The meaning of a legislative word is not like a rock lying on the ground waiting to be found. It is a product of interpretation which is legitimate if and only if the interpretation process invokes criteria which, whether developed by courts or decreed by statute or both, are broadly understood by the legislature, the executive, and the judiciary." To that, we would add something that we've mentioned previously, that is, that the principles of statutory interpretation and the approach taken by the court must reflect the constitutional distribution of powers, and first and foremost, that it is not the court's role to make or rewrite statute law. Lawyers play an important role in this process too. All lawyers owe a duty to the court, and this entails, amongst other things, that they must not mislead or otherwise derail the judicial process. But lawyers also owe a duty to their client. Given most statutes are open to more than one possible interpretation, it will be the lawyer's role to point out to the court all the different ways in which a statutory provision might be interpreted. The lawyer will have to be alive to the fact that some interpretations are more persuasive than others, given the established principles of statutory interpretation. In other words, the principles of statutory interpretation might lead more persuasively to one interpretation than the other. But the lawyer should also play a role in suggesting to the court that it prefer the interpretation of the statute that suits their client's interests. This is the kind of role that you are going to play when you are interpreting legislation. You need to look at the statute and identify the uncertain aspects of its meaning. You need to present different ways in which that legislation could be interpreted. But ultimately, you need to present what you think is the most persuasive or plausible interpretation of the statute, given the established principles of statutory interpretation. You should do that with an eye to the interests of your potential client, but also with that overarching objective that you have to give advice that is consistent with the state of the law.